Chapter 12. Domicile of Particular Persons, Non-Compotes and Paupers. Non-Compotes, SS 264. The general principles relating to the domicile of persons non-compotes are substantially the same as those relating to the domicile of minors. Much, therefore, that has been heretofore said with regard to the latter subject may be applied to the former. As a general rule, one who is of unsound mind is incapable of choosing a domicile for himself, because he is incapable of forming the intention requisite to acquire a new domicile. This is particularly true with regard to persons who are usually classed as idiots and lunatics, and are wholly, or almost entirely, bereft of reason and understanding. But it does not follow that the same incapacity would attach to all degrees of mental disturbance, and it would be difficult indeed to lay down any general rule which would serve to fix the line dividing capacity to change domicile from incapacity. This subject was considered at some length in the New Hampshire settlement case of Concord v. Rumney, where Bell C. J. says insanity may exist in various degrees, from the slight attacks which are hardly distinguishable from eccentricity, to the most raving and uncontrollable madness. It may be general, seeming to affect all the operations of the mind upon all subjects, or it may exist only in reference to a small number of subjects, or a single subject. The mind in such cases of partial insanity seeming to be in its habitual and natural condition as to all subjects and matters which do not come within the scope of the partial disease. In no case at the present day is it a mere question whether the party is insane. The point to be established is whether the party is so insane as to be incapable of doing the particular act with understanding and reason. This would be the essential question now, where marriage is alleged to be void by reason of insanity. And the same test would be applied in determining the question of capacity to change the domicile, had the party at the time sufficient reason and understanding to choose her place of residence. In that case, a woman, insane at the time of her marriage and afterwards, and whose marriage was declared in another proceeding to be null and void for that cause, was held to have gained a settlement by her residence in the house of her supposed husband, it being found that she had intellect sufficient to choose a home. In Culver's appeal, a person of weak mind, but not to a degree which prevented him from distinguishing between right and wrong, or from determining where he preferred to reside and have his home, and for whom a conservator was appointed, changed his place of abode from one town to another within the state, and continued to reside in the latter town, with the consent of his conservator, and it was held that his domicile was thereby changed. The same doctrine was held by Wilder, J. in Holyoke v. Haskins, also a case of municipal domicile, and has been applied in a number of settlement cases, but it has never been extended to cases of national or quasi-national domicile. SS 265. Relation of guardian to the domicile of his insane ward. The relation of a guardian to the domicile of his insane ward is substantially the same as the relation of a guardian to that of his minor ward. First, the domicile of the guardian is not necessarily that of his ward. Second, he appears to have the power to change his ward's municipal domicile. The Vermont case of Anderson v. Anderson was somewhat peculiar. The facts were that who, prior to his insanity, resided with his wife in Woodstock, was removed by his guardian to the lunatic asylum in Brattleboro, after which the guardian, who was also the father-in-law of took his daughter, A.'s wife, to his own home in Montpelier, where she remained until A's death in the asylum. Upon these facts it was held that S. domicile at the time of his death was at Montpelier, and that the probate court there had jurisdiction of his estate. Third, with respect to the power of the guardian to change the national or quasi-national domicile of his insane ward, much that has already been said with respect to the guardianship of minors is applicable. It does not appear ever to have been held, either in this country or in England, that he has such power. Phillimore thinks he has, and rests his opinion upon several Scotch cases, which, however, do not seem to bear him out. Westlake and Dicey maintain the opposite view, and upon general principles there appears no good reason why the guardian should be held to possess such power. SS 266. French law. In France, under the old law, when that country was broken up into numerous legal territories, each having its own customary law, according to Merlin, the domicile of the interdict was not changed by his removal from one territory to another, but he retained either his domicile of origin or that which he had chosen before his interdiction. But under the Code Civil, which applies domicile mainly to purposes of domestic law, it is otherwise, the provision being, the major interdict shall have as with his tutor, and this is understood by French jurists to be a dependent domicile, irrespective of the actual residence of the interdict. To such an extent have some carried this principle that they hold that the domicile of the wife of the interdict is necessarily that of her husband's tutor. Domicile demonstrates the proposition with the remorseless logic of a syllogism. Thus, a married woman has no other domicile than that of her husband. Now the interdicted husband has his domicile with his tutor, therefore the wife has her domicile with the tutor of her husband. This doctrine is denied by others, and it is generally held that if the wife of one who is interdict for the cause of insanity has been appointed his tutress, she has the power to change his domicile by changing her own. SS 267. Relation of father to the domicile of his insane major child. With respect to the relation of a father to the domicile of an insane major, two propositions may be laid down. First, the domicile of a lunatic who has become such after reaching his majority is not changed by the change of his father's domicile, even though he be at the time a member of his father's family, but remains that which it was at the commencement of his insanity. This was expressly decided in the Massachusetts settlement case of Buckland v. Charles Mont, and has the support of Lord Penzance and Sharp v. Crispin and of Westlake, SS 268 ID. But, second, the domicile of a son who has never been of sound mind since attaining his majority continues to follow the changes of his father as domicile, particularly if he continues to be a member of his father's family, the incapacity of lunacy being a mere prolongation of the incapacity of minority. This has been laid down by Lord Penzance in the case just referred to, and has been expressly decided in several American settlement cases. Lord Penzance says, "I can find no authority which defines the effect of a change of domicile in the father upon a lunatic son. It would probably depend upon circumstances. If a man had grown up, married, and established himself in business in the country of his original domicile, and had afterwards become lunatic, and in that state had been taken charge of by his father, the emigration of his father to a foreign country with the view of becoming domiciled there, taking his son with him, might fail to work a change in the domicile of that son. It is not difficult to conceive cases in which great injustice might be done to the interests of others, if the general proposition were admitted that the custody of a lunatic necessarily carried with it the power of changing his domicile at will. But the hypothesis under which I am now considering the circumstances of the present case is free from the necessity of asserting any such general proposition, for I am assuming that George Crispin was of unsound mind throughout his majority. In other words, that there never was a period during which he could think and act for himself in the matter of domicile otherwise than as a minor could. And if this be so, it would seem to me that the same reasoning which attaches the domicile of the son to that of his father, while a minor, would continue to bring about the same result after the son had attained his majority, if he was continuously of unsound mind. The son in this case continued under the control of his father, was presumably supported by him, and if he had not already been in England when his father returned hither in 1843, would, it may reasonably be presumed, have been brought with him. At no period could he, according to the hypothesis, have acted for himself in choosing the domicile, and if his next of kin and those who had control of his movements in life were not capable of changing his domicile, that domicile would, from the moment of his majority, have become indelible. The better opinion, in my judgment, is that the incapacity of minority, never having in this case been followed by adult capacity, continued to confer upon the father the right of choice in the matter of domicile for his son, and that in 1843, if not before, that right was exercised by the adoption of an English domicile for himself, which drew with it a similar domicile for his son. SS 269. Domicile of insane person not changed by removal to asylum. An insane person does not change his domicile by being removed to an insane hospital in another town or county, no matter whether he is placed there by his guardian, or by the authorities of the municipal division charged with his support. And upon the same principle in an Iowa case, it was held that an insane and helpless pauper, who, after for some years dwelling with her brother in B. County, moved with him, with the consent of the poor authorities of said county who were charged with her support, to F. County, where they for some time continued to support her, did not thereby change her settlement. Paupers, SS 270. Domicile of pauper not changed by removal to poorhouse. Analogous to the case of persons of unsound mind who are confined in an insane hospital, is that of paupers who are maintained at the public charge at a county poorhouse. This involves only municipal domicile. It has been frequently held in American cases that a pauper in such circumstances neither gains a new domicile in the municipal division in which the poorhouse is located, nor loses his domicile in that from which he has been removed. The grounds upon which this rule is put are well stated by Walker, C. J. in Freeport v. The Supervisors. He says, as a general rule, persons under legal disability or restraint, persons of non-sane memory, or persons in want of freedom are incapable of losing or gaining a residence by acts performed by them under the control of others. Thus, the residence of the wife or minor child usually follows that of the husband or parent. There must be an exercise of volition by persons, free from restraint and capable of acting for themselves, in order to acquire a residence. A person in prison under the operation of law does not thereby change his residence. So of a lunatic legally confined in an asylum. As these acts are involuntary, there can be no presumption of the necessary intention to change the residence. So of fiends covert and minors. And no reason is perceived why the maintenance of a pauper at the poorhouse should form an exception to the rule. He is placed there by the officers of the law, and in pursuance of its requirements. The act cannot be said to be voluntary, but is induced from necessity. Inability for self-support renders it necessary that the pauper should be supported as a public charge, and the law has designated what political division of the people shall be charged with the support, and has, therefore, given the body the means of controlling the acts of the pauper to the extent necessary to render it convenient for his support. So soon as he becomes a charge, and while he remains so, he ceases to be a free agent, but is in the hands, and to a certain extent, under the control of the public officers entrusted with the execution of the poor laws. By being removed to the county poorhouse, these persons did not lose their residence in the town of Freeport, nor did they gain a settlement in the town of Silver Creek. A former pauper in an almshouse who has been discharged as such, but who remains in the institution under contract of service for hire, may thereby gain a domicile in the place where the almshouse is located. SS 271. Inmates of Hotel des Invalides in France and of soldiers' homes in this country. In France, it has been decided that the Hotel des Invalides forms the domicile and permanent habitation of those who are admitted to it, there to pass the rest of their lives, and there to enjoy the repose which their honorable services have merited. This doctrine might be of some importance in this country in its application to the inmates of soldiers' homes, whose legal position with respect to domicile can hardly be said to be identical with that of paupers, the intimacy of the former being largely the result of choice.